Hello, everyone. Thank you for joining us here today. My name is Gene Quinn, and we're happy to have you here joining us. We're going to get started here momentarily. We'll just give everybody a moment to get transferred from the ready room into the webinar room, and then we'll be off to the races. We have not yet started. I'm just talking to fill the silence so that you know that your speakers are working and everything is good to go. We're ready to get started here. We can probably get going now. I'm sure we'll have more people join us over the first few minutes, but here we go. Welcome, everybody. My name is Gene Quinn. Thank you for joining us here today for a conversation about using AI to supercharge prosecution. We're going to talk about it in two different contexts. We're going to talk about it in the context of drafting applications, and we're going to talk about it in the context of prosecuting applications and using the tools to file office action responses or create at least a draft for you to work with that you can then streamline and find more efficiencies. So we have a robust conversation. Thank you for being here. If you have questions that you would like the panel to answer, please put them in the Q&A box. If you want to chat amongst yourselves, or if you need technical support, or if you have a very specific question about how to do something that goes beyond what we're talking about here today, feel free to put that into the chat box as well. So, Renee, I'll kick it over to you and you can introduce our speakers and then we'll be off to the races.
Sounds good. We will also have someone here from Ankar who will answer questions in the chat box as well about their software. So on our panel today, we have Ted Wood. He's a patent attorney and owner of Wood IP, a Washington, D.C.-based boutique law firm that helps clients from Fortune 100 companies to solo inventors to protect and leverage their innovations. A former U.S. Air Force Lieutenant Colonel, thank you for your service. With over 23 years of service, he developed advanced technologies in electronic combat systems, satellite communications, and stealth. Ted holds a JD from the University of Dayton School of Law and degrees in electrical engineering from Northrop University and North Carolina A&T State University. Next, we have Peter Jensen-Haxel. He is the founder of Jensen-Haxel Law, advising clients from individual inventors to multinational corporations on efficient IP value creation. With experience spanning law firms, venture capitals, startups, and as a co-founder, he has prosecuted more than 100 patents in fields including cybersecurity, AI, machine learning, and advanced manufacturing. He also co-founded the Only Corporation and TerraCylon Inc., and authored the first published article highlighting 3D printing's implications for firearm regulation. Peter holds a BS in physical biochemistry from UC Santa Barbara and a JD from Golden Gate University School of Law. Next, we have Michael Henry with a PhD. He is the founding principal of Henry Patent Law Firm, PLLC, where he develops a growth-oriented IP strategy for high-tech companies building global patent portfolios. With a background in physics, engineering, and mathematics, he has extensive experience protecting innovations in quantum technologies, software, hardware, medical devices, and energy systems. Before founding his firm, Michael managed global portfolios for Fortune 100 companies and research institutes at the top international patent law firms. He earned a PhD in nuclear science and engineering from MIT, where he researched advanced control techniques for quantum computers. We next have Tamar Gomez. She's the co-founder of Ankar AI, a next-generation end-to-end AI native IP platform. Previously, she spent nearly a decade developing cutting-edge AI software for enterprise and governments at Palantir and at Helsing, where she also oversaw their innovation and IP processes. Experiencing firsthand the challenges of capturing and patenting innovations, she founded Ankar AI to solve them. She holds a PhD in game theory and microeconomics from Imperial College of London and an MS from HEC Paris. And last but not least, we have our moderator, Gene Quinn. He's a patent attorney and a leading commenter on patent law and innovation policy. He founded IPWatchDog in 1999 and since has twice been named one of the top 50 most influential people in IP. He's regarded as an expert on software patentability and U.S. patent procedure and has repeatedly been recognized as one of the top IP strategists in the world. Back to you, Gene.
Great. Thanks, Renee. And thank you all for being here today for this important conversation. We're going to talk about using AI to draft applications. We're going to talk about using AI to prosecute and draft responses. And we're going to talk about what it is that you should be considering when you're evaluating tools to make sure that you're going to adopt a tool that works for you and keeps you also out of trouble, which I suppose is probably the table stakes as it is now. Is you need to make sure you're working with somebody who understands confidentiality and that you can trust. So, gentlemen and lady, what I'd like to do is start with your initial thoughts, if we can, to prime the well for the conversation that we're going to have. So, Ted, why don't we start with you? Where do you want the audience to have their mind as we begin the conversation today?
I appreciate the question. So for me, your initial question was, how to select tools that are right for you. The capability of tools is dramatic, from the simplest to the most advanced. I like to use the analogy of from a Chevrolet Malibu all the way up to a Rolls-Royce Cullinan. And so for me, understanding the price points and the pricing models of the different tools and some capabilities you may not need, you may not use those. And so for our team, we're trying to find tools that match our particular skill sets and the way that we practice IP law. We don't want to overdo it, but the tools are exciting. The improvements are dramatic just over the last 12 months. And we've been following this for a while before it was AI, when it was just, helping to organize the preparation of patent applications.
Great. Thanks a lot, Ted. Peter, let's go to you next. What are your initial thoughts?
Well, Gene, these tools are really nascent, but I think they're at the point of immediate productivity. And I don't think that was the case 6 months ago. And I think we finally arrived there. So really their adoption is becoming a fundamental skill, knowing how they work, why they produce what they produce, and their strengths and weaknesses, so you can use them effectively, but not run into the blind spots on them. And in my practice, I've now seen about 50% of the patent applications I file now have an AI component as part of the disclosure. So we're now in a kind of a process where we're shifting from clients being suspicious of use of AI to almost asking, you're using that to make it better, right? I think these tools represent a really amazing force multiplier. You still need a value to multiply with it, but if you have that initial value and that initial knowledge base, they're very powerful.
Good, excellent. Good place to start. Thanks, Peter. Michael, your initial thought.
Yeah, thanks. I mean, very similar to Ted and Peter. I've, had my eye on these various AI capabilities for years and sort of known that eventually it would get to a state where it's really going to be a powerful tool for patent drafting, patent prosecution. And, over the last 6 to 12 months, I've definitely seen that, we're there, basically. We're there where this is not just a sort of a party trick. It really is going to be a useful tool that's going to make our job easier and ultimately is going to produce a better work product for the client and allow us to provide better service for our clients, which is ultimately what we're trying to do. And so I've been really excited to see the various tools that have already come available, including the Ankar tool. We've started using it in our practice, and I've been very pleasantly surprised to see clients' reception to it. And as Peter was saying, clients are at a point where they're all using generative AI and for various purposes. And I think they're getting to a point where they're expecting us to use it to make our work more efficient. Mm-hmm. And so, yeah, I've been very, very happy to see clients excited about it as well.
Good, excellent. And Tamar, your initial thoughts.
Yeah, thanks, Gene. Yeah, it feels like today when I talk to our users, clients are asking law firms to do more, to do faster, and to do it for less. But it's also the case for in-house teams where they're under pressure from the GCs, from the CTOs, and the boards to reduce the costs and still yield as many patents or even more patents than before. So it feels like this pressure puts profitability at risk, and it means that in our opinion, like, technology and good software and AI is no longer necessarily a nice to have, but it's kind of a strategic necessity. And the challenge, of course, that we're seeing, and we're seeing all of the people we talk to ask us like, well, the market is flooded with these tools that all promise speed and efficiency. And how do you, how can we differentiate you from another tool? So what I'd love to share today is from the lens of us as a software builder, is how we build, like what are the key drivers that we take into account when we build the tool, when we develop the features, and mainly what we hear again and again from our customers and from users in general is that people want trust and security. They go together, right? They want ease of use, they want collaboration, and they want customization. And so I kind of hope today to be able to share how we implement these principles in how we develop the tool.
Great, excellent, very good. So now while you all were talking, I published our first poll, which will give us some information about the audience that we're speaking to. So let me share the results here for the first question, which is, have you deployed AI drafting tools? And 43% said yes, and 57% said no. Is that what you expected? Is that surprising? What say you, panel? And while we talk about that, I'm going to publish the next poll question, which is the second piece to this question. But go ahead. Maybe tomorrow I'll start with you this time.
Yeah, thank you, Jean. I guess it's promising because I think the last webinar I was in, the numbers of adoption were slightly lower. So it means that there's definitely a lot of adoption. There's been a lot of adoption since then, and this was maybe 2 months ago. But I think it also showed that a large part maybe of the market hasn't yet. It's kind of like testing to see what are the best tools out there. So surprising, but not that. But also like within the trend that we're seeing.
I was one of the no votes on the last.
Oh, were you?
Yeah. So there you go.
Good. And here you are talking about it today. That's awesome. That's great. Michael, any surprises there for you?
I'm not surprised that it's kind of consistent with just conversations that I've had with other IP attorneys. I find that there are a lot of folks who, are maybe skeptical about how their clients will respond to it, skeptical about security, protecting their clients' information. There are a lot of things to sort of be very cautious about. So it doesn't surprise me that there are some folks who are maybe not adopting it yet, but also, I've also, over the last 6 months, we've started using it. And so as a new kind of user, I know there are others in the same boat.
Yeah. And I'll just publish the part 2 of the question here is about similar numbers, slightly less, but very similar, have used an office action tool. But Ted, your thoughts, and I know maybe I can provoke you here a little bit, because in the green room when we were all talking, you were talking about not to age you or anybody on your team, but I think what you said is teaching an old dog new tricks can sometimes be difficult, and you have some struggles sometimes to get people on your team who have their way of doing it to try something new.
It is not easy. I mean, we brought in. These are not the first tools that we've brought in to the firm, whether it's workflow management or drafting tools, or even an early iteration of these tools. When it used to be TurboPattern way back in the day, it's not easy. Folks, see these tools. Many of us have been practicing from 30 to 40 years, and people are not inclined to completely alter their practice style, and so it's a challenge. I do believe that now, over the last few months, people are more accepting of the idea of having to use these tools. I think everybody, at least the smaller firms, my fear is that if I don't learn everything that's out there and know what everybody else is doing, I'm going to wake up one morning and be irrelevant. And
no, you're never going to be irrelevant.
It's a fear, and I see the numbers. You and I have been doing these. You've been hosting these webinars for quite a while, and those numbers have been, the yeses have been creeping up steadily.
Yeah.
So that's impressive, and it reflects what I hear in conversations from colleagues and from others. And you mentioned clients are using those tools. So are inventors. I've had invention disclosures that I'm reading, and I'm like, okay, wait a minute. This is AI generated because it's hallucinating. Where did this word come from? And it's I
Or
recognize
you
that
have
language.
experience with that particular inventor from that particular client, and you're like, I know that this inventor didn't write that. Right. I mean, but it's true. The clients are using it, right? And
Yeah.
it is, like the very first time that we did a webinar like this, one of the first things, and we had to spend a lot of time on it, was how do you handle client resistance? Because that was, clients were like, no, we're never going to do this or that, and then all of a sudden, the board of directors, people who aren't, in our space, wanted to companies to answer the question, what is your AI strategy? You need to be using it where it makes sense to use it, and what's your plan? And then it just totally shifted. And now if it hasn't happened already, you're going to start to see clients want to pay you less because of AI. And that's a different conversation for a different day, but that is coming. So if you're not using it now, once that does arrive, you're going to be priced out of the marketplace altogether.
I think it has arrived. Over a year ago, I had that very conversation, and I'll poke the bear a little bit. I'll ask both, Peter and Michael, for do you have a fear that the more efficient you get using these tools, and the more your clients are aware that you use them, there's going to be that suggestion, maybe ingest initially that, hey, that we split this efficiency. I mean, I've had that from several large clients. One ingest and one, we had a very frank conversation, and they're trying to force their outside firms to use these tools specifically so they can cut prices.
So what say you,
so
Michael?
there, I said it.
Yeah, I mean, that was actually, it's a great point. It's part of the conversation that I've had with our clients. And as we've started using this, I've taken the initiative to talk to our clients and say, hey, this is what we're doing. We're trying this tool. This is how we're going to be using it. And, some of them just said, great, wonderful. We love that you're being, tech forward, go get them. And others had questions. A lot of the questions though were about, how are you going to use this? And I, assured them that, hey, the time that we save is going to be passed on to you as a lower legal fee that you're going to pay us. So it's a win-win. And we believe that, this is going to provide same or better quality work product, and it's going to save you money because it's saving us time. The work that we're doing, almost all of our work is on an hourly basis. We're not doing the sort of flat fee model. And so they see that directly on their invoices, how much time has been spent. And, as we save time, they'll save money. Of course, the other questions are around, are you still protecting my confidential information? And I think that as patent attorneys, that's something that we always have a heightened awareness of, and we want to be able to reassure them to. And so we've also had those conversations about, making sure that we're protecting the confidentiality of their information and not jeopardizing anything on that front.
Yeah.
So I don't want to get too sidetracked. So I'm just going to put a mental note down that we got to circle back and do a conversation, Michael, about how you're convincing your clients to pay you an hourly rate.
Hey, I was thinking the same thing. Like, where did they come from?
Yeah, I mean, but that would be one great way to to do this, and maybe in the end run, that is a advantage for patent attorneys to get back to, because I know a lot of folks want to get back to that, rather than trying to guess, and then not guessing wrong. And then the client comes to you and says, oh, but we're going to do a string of continuations and, make it up on the back end. And then they never arrive. And, bulk price for bulk work works when you get bulk work. It doesn't work when you're not getting the bulk. So that's an interesting conversation to have. Maybe this will do good things for the industry. But Peter, your thoughts there before we turn it over to Tamar.
I work with a lot of venture-backed startups, and I think in their mind, they have a fixed budget for IP. And because of that, they just see it as being able to go farther with less.
Mm-hmm.
And so I think if you're looking for clients that have more of the profile of, we have unlimited opportunities and a limited budget, then the AI tools become a real selling point. because you can tell them we're going to be able to build a much larger disclosure you're going to have more flexibility with,
Right.
and they get off of price efficiency.
So my take on it, not that anybody hasn't thought about this, but one of the things that you might think about saying is like, if you haven't been paying attention to what's going on at the federal circuit only ever asks for more disclosure. The district courts only ever are left asking questions. You can file 100 pages and they're like, oh, well, but you didn't say this or you didn't say that. And now I've started seeing increasingly, and this has been an issue with examiners for a long time, at least some examiners, but I'm starting to see it. It just came up last week with the federal circuit. The name of the case escapes me, but the federal circuit pointed out that, well, this was only mentioned twice in the specification. And they treated it therefore that as if there was no support for it. It's like, no, that is literally an admission that it is supported because you found it twice. And, what they were trying to say is this was not the thrust of the invention and you're making this up and you're after the fact. And it's like, but you admitted, your honors, that there was support there, right? I mean, so they want more and more and more and more. And one way that you can do that is take the budget you're spending now and actually give the federal circuit what they claim that they want. I think AI is going to be very, very good at that. And people who aren't just trying to push down the price are going to get tremendous quality patents using AI. That's my opinion. But Tamar, done enough talking here. I want to kick it over to you because I know you've got some slides you'd like to run through to show people what the tool is capable of.
Yeah, absolutely. Thanks, Gene. I might actually run you through a presentation and quickly do a demo as well to make it kind of lively, and then we can kick it back to the lively discussion that we have. Well, I just wanted to share with everyone kind of a quick intro to who we are, Ankar, what are our principles of like when we build software, and like show you as well our latest office action prosecution tool that we've released and that we're releasing both in Europe and in the US. But I'll start with a quick presentation. So we are a company that was started in 2023 in London. We're kind of on both sides of the pond in the US and in Europe. My co-founder and I are actually from Palantir, which is a large US tech company. We used to build software, military-grade software for the DoD and for large enterprise around the world. And as part of that, of these roles, and especially for me as part of my role there, I kind of like experienced firsthand the challenges of going from an idea to an invention to a patent, as we were trying to like build together a patent portfolio ahead of the IPO of the company. And so thought that the software tools out there to help empower inventors and IP professionals, just not at the level of how critical the problem is for the value of companies and for these IP professionals. And so we decided that, okay, we know how to build software. We've built software for 10 years. Let's go and build like the best software out there for this problem and for this really important problem for innovation. And so that's what we did. And where we started from initially is really from working with in-house teams, because we came from in-house, so I guess we had more affinity with the problems that the in-house teams had. So we worked a lot like with large companies in the auto sectors, worked also in pharma. We still work obviously with these companies in cosmetics and consumer goods. And then little by little, these in-house teams referred us to their law firms, because I think, and to kind of like to the conversation that we were having before, I think they saw the value of the tools, and they thought, well, if we're using it, if it's accelerating our own prosecution process in-house, it might as well be accelerating our partners, our IP partners out there. So we've had a lot of referrals, and then we started like growing organically with law firms and around the world. And basically, what I wanted to show you today is, so we have a drafting assistant that Michael and Peter are using. So I'll let them talk about it because I don't want to overload with technical information. And I think users are the best to describe, their experience of the tool much better than I would. We're releasing this office action prosecution tool that we've been working on for some time, and so I wanted to share that in a demo today. And then we have an infringement detection tool, which we showed at the last webinar. Boris from Nexence was there to talk about it, but I'm going to focus on office action today. So I'm going to share another tab just to show you kind of how it works. I'll go quite. You'll see it'll be a pretty zippy demo, but it's kind of to show you kind of the principle of the tool. So basically, we started working on prosecution kind of like slightly after drafting. It was kind of the natural follow-on of drafting because we started deploying the drafting tool, and then the patent attorneys were like, well, if you can help me with my drafting, can you please help me with my prosecution? It's all, the split of my time is 30-30 on that. So can you please also accelerate that? And so we kind of looked at the process from like, okay, there's a kind of like part of the process which is fetching all the documents, and that takes some time, and that's like pretty low value add. Is it something that we can accelerate? Then there's a second part of the process which is more like analysis. So it's like, okay, what are the objections? What are we talking about there? Is it novelty, clarity, other objections, trying to understand where they are in the disclosure? So a lot of reading, and it felt like a lot of the users were spending a lot of time scrolling through a lot of pages. So we thought, okay, how can we help users get to the relevant piece of information as quick as possible? And then the third part of the process was actually action in office action. So like answering the office's objections. And we thought, okay, how can our user kind of leverage AI to come up with arguments, potentially amendments, accelerate changes that they want to make in the claims and in descriptions? So you'll see these three phases and how the tool kind of helps with them. So you'll see here, you can kick off a new office action. All of your office actions are obviously in a project that you can keep, that you can share with your colleagues, that you can also share with external, if you're with your client externally through like auth-less sharing. So all of that remains perfectly secure. And then the first part is really this input part. So this example is on an EP case. Basically, you can create a project. So you just enter the name of the number of your application, and the tool will automatically go and fetch all of the relevant documents and the latest office action, the latest letter. So it already saves for our users a bit of time to go into the docketing system and sifting through all of these documents. And then they're pulled there, and you can obviously look at them. You can have a look at all of these documents, and then you can start running your analysis. So that's more of the analysis part of the workflow. And here, the first thing that the tool does is it will provide you with a high level, concise summary of your office action. And a summary of the opinion, a summary of the application, a summary of the prior arts. And that is useful, or users have found it useful, because oftentimes, the office action comes up 6 months after they haven't heard about it for 6 months. They need kind of a refresher to see what they're talking, what this is talking about. And they can very quickly see that, okay, we're talking about 10 objections on novelty, and then objections on other general objections. And I can go and okay, I'm going to dive into that basically. Then you can dive into the objections, the specific objections, and for each objection, you can see summarized here, okay, this is an objection on claim 1, and it's relevant to the first disclosure. And you can very quickly look at open the disclosure and see automatically kind of the tool focus and zoom in on the part of the disclosure which is relevant for the objection. So you don't have to scroll through hundreds of pages to find the right snippet of information. So what we've done is highlighting that allows you to see in blue what are the current objections that are highlighted, and then you also see in red objections of other related to other highlights related to other objections in the disclosure. And then once you've started looking at the documents, you can start building an argument with the tool, and kind of you can treat the tool as a sparring partner really of your sparring partner basically on your office action and on your prosecution. So you can ask questions like, oh, can you suggest amendments to this claim? Can you suggest arguments against this objection? And it will systematically cite where the information comes from, because we provide these very strong guardrails whereby we force the tool to kind of have a specific reference in the disclosures and the objections, etc. And you can start building your response letter, and then you can also ask the tool to generate potentially snippets of this response letter, and so on and so forth. There you go. I made it. There are a lot of other features, but I didn't want to make it a feature-heavy demonstration because that's really boring. But I kind of wanted to show you the flow of how it can accelerate you and really become your assistant in these office actions.
Okay, great. Thanks, Tamar. So, you know, I've been impressed by looking at what this tool can do, and I'd like to get folks, you know, feedback on this on the panel. Maybe I might try and provoke you to go in a certain direction because of the comments that we're getting, which I think are already the stuff that we were all talking about in the green room that we thought people would be wanting to hear about. But Peter, one of the questions that has come up from somebody who is a solo is that the question about, does using AI really save time, or does it just add cost? And I think, you know, a while ago, the answer may have been, well, you know, it's maybe a wash, but I think the tools have gotten a lot better. And I know this was something you mentioned when we were just talking offline. Can you share your thoughts?
Yeah, it's a really good question because it's the first one that I was thinking of, you know, when I began playing with and adopting AI tools. And, you know, one of the hardest things as a solo, right, is when do you invest in training someone else, especially to do things like write the detailed description? Do you expand and hire an associate? And what I've found is that having this AI tool available to me, it's about equal to someone with about 2 years of experience in terms of detailed description writing. And that's very helpful for me. The first application I drafted, I saw a 10% increase in efficiency, and that was even with trying to learn, you know, the system. And by the third application, I was at about a 20% increase in efficiency. And at some point, you know, I'm sure there'll be an asymptote, and we'll kind of see it taper off. But that's still very worthwhile for me. So does that answer your question?
It does. And I also was thinking, you also mentioned something that, you know, I hadn't really thought about, but about how you seemed a little, I think you said you were less stressed, or there was less anxiety, or how did you put it?
Yeah, you know, that's the efficiency gain is not the whole story, because one of the things that was really nice was instead of investing 15 minutes in research about a particular industry, you could ask the question and have it delivered to you and then review that. So what used to take 15 minutes now takes 2 minutes, and it was really well written as long as you knew exactly what to ask for. And the second part is that I was just less fatigued when I draft. I find that I don't have to have the highest cognitive function available for drafting. I can now do it, you know, draft for longer periods. And you know, that alone is very valuable because yeah.
And do you think that's because of the tool, you know, like being almost like a brainstorming partner? So it's like it's asking you to pull stuff out of you rather than you come up with it out of whole cloth.
Well, I think one of the things that helps you realize is how much mental energy it actually takes to write versus review and correct.
Mhm.
And that doesn't mean the quality is going to be any less. But it is really helpful to have a partner give you that initial piece. It does shift a little bit of that workflow to upfront investment, because you do need to work on the claims and make sure you have a really good starting context. But as long as you invest a little bit extra time up front, you get it back and more on the back end when all that context gets pulled in and you get all that good drafting to come out of it.
Okay, great. Michael, I want to pivot to you. And one of the things that has come up in the questions is about interesting use cases. So I don't want you just to comment on that. You can comment on anything that has come up so far, but I definitely want people to hear what you were telling us in the green room before we went live about the use with respect to continuations, for example.
Yeah, sure. Happy to comment on that. So one of the ways that we've used the Ankar tool, like I mentioned, we've kind of just started using it about a month ago, so we're still kind of learning our way around it. And one of the use cases that we found, just sort of discovered, was where our client wanted to file a continuation and said, hey, we want to, you know, basically cover this at a conceptual level. Their input was, and so I provided the specification of the original application, almost like an invention disclosure, to the Ankar tool, and said, hey, can you, draft a claim set that covers this, and kind of give it the conceptual level, even maybe tell it where to look in the description. And it was able to create a claim set that was well supported in what I had provided. And then, of course, we go back and edit that, and make some tweaks and additions to it. But that was a very useful process that what normally would have taken me maybe a couple of hours to study the detailed description and pull out the sort of language around this certain topic, the tool did for us very quickly. Another sort of way that I've used the tool already is, so Peter, as Peter said correctly, you do need to do the work up front to draft some claims and sort of guide the AI drafting process, but also the Ankar tool will draft claims for you if you want it to. And so I've kind of tried to do both. So draft a full claim set based on sort of what I normally would do without using the tool, but then also have the tool generate some claims. And I've actually been pleased to see that maybe it picks up on something in the invention disclosure that maybe I wasn't quite as alert to. And so I've thought, well, let me add some dependent claims that cover this, or let me make sure that I've got, this language in the claims that I can tell the invention disclosure was emphasizing or repeatedly using that maybe I wasn't picking up on. So I think those are just a couple of things that, beyond just the, standard drafting, a couple of things that I've found very useful so far.
Okay. And Peter, I think you mentioned something about use cases where you were asking the AI to provide use cases that then I suspect you then put into the specification as examples, or how did that work?
Yeah, we actually worked really well. If you give one example for say one industry of a use of an invention, and then you ask it to apply that to another industry, it was excellent for that, right? And that also saved a lot of time, and there were some insights in there as well that were really helpful and led me to draft another example, right, off of that. And so having someone, right, a system to bounce your ideas off of, and remember, right, these AI systems, there's a vector field behind it, and it's looking for related concepts and related words. So when you ask the right question, it's going out and gathering other related words that are going to get pulled in, and you get this richness to your specification of vocabulary you wouldn't typically use, new facets from which to describe the invention. So, that provides, I think, a lot of value to the client.
Okay. I'm going to give a thought, and then Ted, I'm going to give you the floor to respond to everything everybody said so far. But one of the things that has come up in the Q&A is that the tools that are available seem to be more developed with respect to drafting than with respect to office action response. But one of the things that I think these tools do extremely well is, and it will cut your time down, right? Is when you're reporting on office action back to the client, and you're trying to I mean, because you can't spend the time it would take to prepare all the arguments and all the amendments and say to the client, oh, do you want me to do this? And then if the client says no, then all that's wasted time. But you have to give the client some kind of idea about what is in the office action. And, based on my preliminary reading of the office action, the examiners use X, Y, and Z. It seems to me that we can make arguments about that, and we have support in the special. You've all written those letters, I'm sure. You got to write those letters as quickly. They got to be accurate, but they got to be as quick as possible, because they're largely free, right? Unless and hopefully maybe you factored that in on the front end, the need to do that, and maybe you'll factor that in somehow on the back end that you did it, and maybe have these understandings. But that cannot be a project that takes you an hour or 2 hours or half a day, because you're not going to get the money back. So being able to know very quickly and reasonably, maybe not with perfection, but reasonably, what is the examiner saying, and convey that to the client, I think is an enormously helpful tool. And I do think, and I shared this with you all in the green room, is, when you get these office actions back, and undoubtedly you think, oh, the examiner's an idiot, the examiner's wrong. I know I've got support for this, and I know I described, and then you did it 2 years ago, and then you go back and you look, and it's like, oh, that maybe wasn't quite as direct as my memory suggests that it was, and so it takes time to ramp back up. So anything you can use to help you get ramped back up when you pick up the office action 12, 18, 24 months later, I think is very useful and very helpful. So Ted, there's a lot on the table. Now, just so the audience knows, you have not used Anchor, but you have evaluated a whole bunch of these tools.
I have.
So feel free to comment on what's on the table. And maybe if you want to ask, Peter and Michael, as somebody who has not used the tool yet, a question, go for it.
Yeah. So, and Jen, you kind of stole my thunder when you mentioned that a lot of the comments are indicating that the tools are better for drafting than they are for office action responses. And so, Peter and Michael, you both have used the Anchor tool, and even if you've tried other tools, what are your thoughts about that? And I'll share the reason I'm asking that. And one of my colleagues and I sort of talked through this a couple of days ago. What I find is the tools are great at helping you sift through a lot of information and get started early. And I learned to draft claims from the old school. The person who taught me, you don't start writing until you've read Landis on claim drafting. And I'm kind of dating myself by even reciting that text. And then you start with 3 sharpened number 2 pencils and a dictionary and a thesaurus. I mean, he went through this entire routine, and I learned the importance of the words in claims. And so these tools help you get started. But what I've noticed is that and this may have been 25 years ago or more, one of the first office actions I struggled with, I had to recognize, I had a lot of outputs coming out of a block diagram, and there was one output that was not labeled that was fed back into the input. And it took me a long time to recognize that there's a feedback loop. It wasn't labeled. It was mentioned in maybe 2 or 3 words in the spec. But what we're finding is that these tools don't do that kind of critical thinking. They can help you parse through a lot of information. They're more helpful. They appear to be more helpful drafting because there's so many components to drafting. But on those high quality and very critical thinking aspects of a response that can turn on the slightest distinction between a reference and the invention, what we found is that they don't do that as well. And I think somebody in a comment mentioned it's like having an assistant at the 3 or 6 month level. What do you find? And have you tested out the Anchor tool to find out if that's a fact or not?
So we'll like both of you to respond. Michael, we'll start with you, and Peter, I'd like you to respond to that as well.
Yeah, sure. We have not used the Anchor tool for office action responses, so I can't speak from experience on that one. I think, obviously it's almost like the opposite end of the spectrum, as Gene was saying. In a specification, it's like all we ever want to see is more description, more technical description, but in responses, it's like we want less. You want to try to be as concise and short-winded as possible, and so a lot of my time in office actions goes into how can we say this more concisely. But I think the area where it looks like Ankar's tool is trying to do a lot of legwork, and also what I've used other tools for is the analysis. So one of the most annoying things that I'll run into in my practice is an examiner who will cite, I bet you've probably all seen examiners who have they have a favorite reference that they like to apply, and it's like a 200-page patent.
There you go.
and they're like, I know it's in there somewhere. Like, you do the work, Mr. Patent Attorney, and you tell me that it's not in there. And so for that type of thing, I mean, we can't read a 200-page document and actually understand the whole thing within a reasonable prosecution budget. But an AI type tool, and it sounds like this is what Ankar's tool is going to help with, is to say, here are the relevant sections of the document to focus on, even if the examiner didn't cite them. But also you can say, does this document talk about XYZ, whatever it is? Does the document disclose super heterodyne radio system or whatever. And that type of thing that could be very reading intensive and fatigue inducing, I think AI is primed to do that type of thing very well. And maybe, it could make mistakes, obviously, but it's going to be a very helpful pointer in the right direction.
Well, it can't make any more mistakes than the examiner who just threw a 200-page reference over the transom because they didn't read it.
Agreed. Agreed.
And but Peter, we'll go to you, but tomorrow I'd like you to comment on this as well, like what you were trying to accomplish and what you think the tool does accomplish with respect to office actions. But before we have tomorrow respond, Peter, your thoughts on that aspect of the tool?
Yeah, I mean, when it comes to office actions, one of the, I think, ways that AI is very helpful is essentially what it's always doing is trying to find relationships between things. And especially in software inventions, sometimes the same word can mean very different things in different applications, which has always been a challenge for examiners. I get rejections back and they're citing a coordination server, but it's like completely different use case. So it's really nice having a way to automatically go through and gather the additional context to say this is not the same thing at all, right? And get pointers there. That's one helpful aspect. And then, Gene, I'd really like to hear your opinion on sort of subject matter eligibility, because a lot of times, and I don't mean to really disclose how this happens behind closed doors, but a lot of times the examiner throws something out and it's just boilerplate 101 rejection. And then I just say, no, it's eligible. And then we get on the phone and negotiate, right? But you at least need to say something that's responsive up front, and writing those responses is always a slog. And so having something to assist with that process before you just pick up the phone and negotiate, I think is very helpful.
Yeah, I think a lot of time you're being generous. You say sometimes the examiners use boilerplate. I think it's like with one-on-one, I think it's 100% of the time. And, I wonder whether they're being encouraged to do that to force applicants to make a record. I think some of them are doing that. So I think that's why, and then others of them, as we all know, we don't need to spend too much time on this. There are certain art units that just don't like issuing patents, and they use the 101 as a tool, as a crutch, so that they don't have to. But what I do see a lot is these real circular 101 rejections where they pick on something you've said, maybe even like in the abstract or in the title, to define the idea. And then that's all they read. And they read out all of the tangible steps and all of the context and all of the use cases. So I do think that's one of the reasons why I was really interested in getting you to comment on the use cases, asking, like, well, can you give me a use case in this context or a use case in this context? Because if you can, sometimes when you start looking at these things like this as the invention, and you miss the forest for the trees. If you can keep it at arm's length, you don't miss as the drafter the forest for the trees, right? And if you can get that help and it gives you some context, some ideas about what to put in there, that can go a long way, I think, to overcome these 101 rejections, assuming you have an open-minded examiner. Because we all know, look, a drive shaft is not an abstract idea. We all know that, right? But so there's all the MR machine is not an abstract idea. I mean, you can't address the one-offs. So, and I know people are thinking about that. Oh, examiners aren't. No. Let's worry about the reasonable examiners right now, because you're never going to have any tool that's going to help you with the unreasonable examiner. And if you have the reasonable examiner, I do think those use cases and helping you blow this out and explain it, because I think that's the problem a lot of times, and what is frustrating me, and I'll say this and shut up, with the 101, what frustrates me is not killing things that are non-inventions. What 101 does is it kills innovation. And if you told me what the mark I had to hit was, I would hit it. I'd give it to you, right? So I think AI used properly and prompted properly and given good input in the first instance can really create something that is quite tangible and should get you out in almost an end-fish way. And I think, Michael, I don't know whether you mentioned this when we were in the green room or whether it came up already here when we were talking, but you know, that constantly trying to get the AI to help you with, well, what is the value add? What's the innovation? What's, you know, and even if you don't put that specifically into the application, you cut it out, you know, the way that the AI told it, you know, because you don't want to say things that are going to walk you into a KSR problem. But you got to have it in there so that you can make the arguments later on in the office action. So one of the things that, and I get that a lot of the tools, people might not think that they're as good for the office action part yet. I think that there are very specific use cases on the office action that you could never do, like Michael was saying, the 200-page reference.
Oh, yeah.
But if you do a really good job on your specification and have a lot in there, it's going to make the office action stage much smoother. So Tamar, there's a lot on the table. I'd like to get, you know, as you're the one who created the tool, what say you about some of these questions?
Yeah, I mean, all really, really good points. I think the big thing that we keep in mind basically when we're building is there's no magic wand, right? We're not going to go from like an input or an invention disclosure provided by a customer to a perfectly to a perfect pattern, because there are so many things that happen in between, so many different ways to draft the claims, and a lot of it comes down to the experience of the attorney. But where we found that that tools are useful both for drafting and office action is kind of like automating these very manual and like low, you know, value adding parts of the job. So, you know, fetching documents, identifying in a very long documents what are the relevant places, like Michael was saying, maybe like automatically changing the reference signs in a draft when you've yourself changed the reference sign in an image. All of this stuff is really like just saves a lot of this kind of boilerplate time. And then there are more clever things that can be done that can also help, like that also Peter was mentioning, which is more around, okay, I have a sparring partner here, like that is prompting me to be more precise or more clear. And here, I think the way that we've gone through a lot of cycles of iterations, by the way, like we didn't have that from the get-go with the engineers. It took a bit of time for us, and okay, what's actually useful is for the tool to generate text or to like provide answers, but always give a citation, right? So like typically we in an office action, when the tool will suggest an amendment or like an amendment for clarity, for instance, issue, like we will cite like guidelines or, you know, going forward we'll cite case law. And here it's just like, basically it's almost like it's really your assistant or a paralegal like bringing to you the right place and where you can actually the right reference that you can leverage as the attorney. So that's like the second thing, which is more like, okay, those are the more clever things that the tool can help with and help you like accelerate. And then the third thing is really, really software. And this is what I love. It's a lot of it is collaboration and customization. So it's like sharing, you know, so many attorneys I talk to complain about the amount of emails and Word documents and versions of Word documents that they have to handle. And this is, you know, this feels very like low level, but actually if you can save a lot of this time, it's huge, right? And so just being able to comment on a draft, see what is the level, you know, where is your comment at, share that with clients in a secure way, all of this stuff. And then the second thing is on the customization, which is super important. I think there was a question on the chat is, okay, you know, I'm answering an office action for something that's been filed initially in the US, and it's in another country. There are questions about languages. Can I, you know, how can I translate? Can I have a draft in a different language? So just being able to handle like multi-language, multi-jurisdiction, different rules, different guidelines, and have all of this information in one platform, I think that's immensely useful. We've seen that it's been immensely useful.
Yeah, no, I think so. So I'm looking at the clock and we're running low on time. So I'm gonna I'm going to jump and say a couple things, and while I give you a moment all to think about what your parting message is going to be to the audience today. We have a question here about whether or not the tool can be used to draft and update a specification. And we talked about that in the green room, and the answer is yes. That's one of the things that is really great. And you can also, I think, use like the way Michael was saying, use it for continuations. Here's the spec. What claims can I get? Take the product that you got and then run it back through the system to see what claims it may want you to add. And then you may wind up in a situation where, oh, I don't think that's in the spec enough, and you can go back and forth that way. And I think that there's a lot of real creative stuff that you can do there that works as a fail-safe, and will create a much more robust application. The other piece here that Michael mentioned I think it was Michael you mentioned before we went live, I just want to share, having been somebody who has taught people how to draft in law school, and then we've done for years a patent prosecution course for people who are attorneys. And one of the things that is difficult when you're teaching is I got to teach you how to do it my way, because I can't learn, if I got 30 people in the class, I can't learn 30 different ways that would be acceptable and give you feedback. It's just not possible. I'm going to teach you like I'm the senior partner, and you're going to do it my way, right? What Michael said, and I thought this was very insightful, is that getting everybody on his team to use this tool then gives him something that he understands and is familiar with. He knows where things are. He knows how it was drafted. It's uniform. And then he can spend less time doing value add because everybody's doing it the same way. That's, I think, a use that I hadn't considered, but having spent a lot of time trying to teach people how to do things, I think is something you can't underestimate how important that is. So there's my thoughts. And what I like to do is let's go around the horn and get your final thoughts. If there's one thing, and hopefully there'll be more than one thing, but if there's one thing the audience takes away and remembers from this conversation, what do you want it to be? Peter, we'll start with you.
I would say manage your expectations, come in with an open mind, and meet AI halfway, right? If you need to slightly change your style in order to get a better outcome, invest in figuring out what that is, and then you'll see the dividends.
Great. Thanks, Peter. Michael.
Yeah, sure. Thank you. I mean, I feel like at my best, I'm a strategic partner for my clients, and I'm not just a drafting assistant. Of course, I love drafting. I'm doing a lot of drafting. We as a firm are doing that, but I feel like AI tools are going to help us use more of our time to be strategic and thoughtful, and to provide legal insight, and less of our time drafting. And so I think it's a value add to the client, and it allows me to do more of the work that I actually enjoy doing the most.
Great. Yeah, no, and I think that's one of the things AI does, is it really lets us be lawyers, do what we went to law school to do.
Right.
So thank you, Michael. Ted, your final thoughts here today.
Yeah, I agree with everything that both Peter and Michael said. And the one thing I would leave with is, regardless of how good the tools are, they are just a tool. And Gene, I share the analogy that I'm a tool gadget. I'm a gadget freak. I have all the tools, and I try to do the tile on my kitchen floor with the best tools. But if you look at it at the right angle with the sunlight, first thing you'll say is, "Oh, you did that yourself." So the tools are only going to get you so far, and that critical thinking that we're going to need going forward, because more of the inventions are going to be infused with software and AI, generative AI. These tools will allow us to spend more time on those parts of our responsibility than some of the more medial stuff.
Yeah, absolutely. So thanks, Ted. And the final word goes to you, Tamar.
Thanks, Gene. I wanted to just touch on software security, because we didn't talk about it too much, but it's always a question we get. Mm-hmm. And as far as tools go, and data and IT security goes, there are really defining principles that will make a software enterprise grade, military grade secure, and that are the key kind of things you should be asking when you're, when you're evaluating these tools, then that is like whether the software uses your data to train models, whether third party or proprietary models. That's super important. We don't use data by default. Where the data is processed, if you're in the US and you're working on like sensitive US stuff, the data should be processed with servers in the US. Same in Europe, it should be processed with servers in Europe. And so the tool should be able to have two servers in different places, and then the data should always be encrypted. And so you have to check that it's always encrypted. And so these are the key principles that I wanted to give everyone before we go.
Yeah, no, excellent. I'm glad that you did. Once upon a time, that was the stuff that everybody wanted to talk about for the entirety of the webinar. But if you have questions about security, it's not that we're trying to avoid that. Happy to get answers to you to make you comfortable to use the tool, or at least try the tool out. And I see we're just over. I'll just end very quickly with this. I know a number of you said that you would be interested in a free trial, and we'll make sure that someone follows up with you about that. And I know we didn't get to all the questions that you asked. I'll make sure that the panel gets those questions, and somebody will take time to reach out to you and try and get you the answers to your questions. So we thank you all for being here with us today to spend a portion of your day. I encourage you to test this tool. The time is coming that if you're not using a tool, it's going to be too late. Because other people are using it and they're going to be pricing you out there, and they're going to be doing better things. And it's never too late to get started, at least not right now. So get started, learn the tool and how to use it. And maybe you'll come up with some interesting use cases. And if you do, we'll have you join us on a webinar. So thank you all for being here, but that's all we have for today. So bye for now, everybody.
All right. Thank you.
Thank you.